Okay, in addition to these concepts of contracts that are either void or voidable, it's also important to discuss what we mean when we talk about the enforceability of contracts. When we talk about whether a contract is enforceable or not, that's a little different than whether it is either void in that it cannot be done or voidable in that it cannot be done unless one person ratifies it. The enforceability of a contract has to do with whether we can go to court and ask them to enforce the obligations that are contained therein. So what that means is a contract may be unenforceable, but not necessarily illegal for you to perform. You could still perform it. It may be fine for you to go ahead and go through with it as long as both parties agree. But if there is an issue, if there's some sort of dispute, if the contract is found to be unenforceable, or if one of the clauses that's at issue is found to be unenforceable, even if the rest of the contract isn't, then the court is not going to help you. It's not going to give you a remedy on that because of this concept of unenforceability. There are certain types of contracts maybe, and also particularly certain types of clauses, but a court will not enforce against somebody for various reasons of justice, fairness, and equity. And so the book goes through a few examples of these. First, it talks about an exculpatory agreement. These are also, you'll see them called waivers or liability waivers or a release of liability. It's essentially a contract between two parties. You have an offer and acceptance and you're exchanging something. And in consideration of this exculpatory agreement, which is intended to exculpate one party from some wrongdoing. It's a document essentially saying, look, if we go through with this, you agree that as part of this bargain, if X, Y, and Z or any of those go wrong, you won't hold me liable. So I'm attempting to get out of some responsibility that might otherwise exist under this ability that we have to, under this freedom for us to contract and make the deals that best suit us in our situation. So if somebody may have something that you really, really need, and maybe they want you to waive any possible liability because it's more important to you than it is to them, and so that's one of the things they want you to give up are certain rights to sue them if certain things go wrong. Now you'll see these a lot, and you've signed plenty of them yourself. You may have signed one even today, especially if you signed up for something online. We now enforce digital signatures, so you can click on something. You can click that I agree to the terms, and a court will enforce that against you as a general rule as being just as good as you signing, and the court will assume that you have read whatever's in there, even if you didn't. So you need to be careful about that. These are generally enforceable as long as they are, as long as they tell you what rights you're giving up. For instance, there's a case in the tort section that is called Getsy versus Lifetime Fitness, and at issue there was the question of assumption of risk, which is a defense is a tort defense, but it's similar to what's contained in an exculpatory agreement because it's a waiver of liability. And in that case, the clause in her gym membership contract was upheld because it said specifically you're waiving liability for use of the gym equipment. But if it said something like, you promise to not hold us liable for anything that shall ever go wrong, ever, forever and ever, that doesn't really tell the party. It's too vague for a party to really understand what it is exactly that they're giving up. So a court may not enforce one that is like that is so vague. Contracts that are unconscionable, these will not be enforced because the terms in the agreement would be shocking to a reasonable person, and we wouldn't expect. Well, they occur like this in situations where you have unequal bargaining power.
and a lot of us have these with businesses. If you want a cell phone, you're going to have to sign Verizon's contract or AT&T. You don't really have a choice about that. It's a situation like that coupled with um, terms that are so unfair and so lopsided towards one party against another that they would shock the conscience of a reasonable person. Quick example of this is Williams versus Walker Thomas Furniture. It's a case where it was a business that it was a sort of lease to own business where people could get pretty much all their household items from a refrigerator to a couch and all of those. And under the terms of the agreements, you would basically pay rent payments until you made the requisite number of payments with interest, and then you would come to own the particular household good. Under the terms of the agreements, though, that they gave to customers, it said that if you missed a single payment on any of the items, even for the other ones that even though you had paid for completely for all the other items that you got, if you missed one payment on one item, that allowed them to call the loan on that item and then repossess not only that item, but all the other items that you had already made full payments on, including interest. And so it was a really just grossly unfair way to do business, and that's why it's an example of something that we consider unconscionable. It's something that's done essentially without a conscience. That's not what somebody would, a reasonable person would do to somebody. You have the right to maybe call the loan on that one item, but to take back all of their household items for that one error, that one missed payment, the court found that was just a term that was so unfair as to shock the conscience. So that's how unconscionability works. Contracts and restraint of trade. As you may know, we have many laws that are built upon a public policy against unfair competition in the marketplace. In a capitalist marketplace, we want competition to be as free as it can be. And so contracts and restraint of trade are ones that hinder free enterprise, potentially. And these come in a few different forms. For now, the one that we discuss in this chapter is called a covenant not to compete. And we'll come back to a couple of others in one of the next chapters, but we'll just stick with this one right now. So covenant not to compete is an agreement that an employee enters into with an employer that says once you leave here for whatever reason, it could be only if you're fired, it could be only if you leave of your own free will, or it could just be at any point, whatever reason for your separation. It says that that you will not compete in the same industry with them for a certain amount of time. Now, these can be enforceable as long as they're reasonable in three areas: the time, the scope, and the geographic location. So say you work in the fashion industry and you leave your employer for whatever reason, maybe you're just moving locations for some unrelated reason. And you have a covenant not to compete that says, you're a fashion designer, and it says you can't work as a fashion designer for 2 years in the state that we are established in. That would probably be reasonable. There might be a few more facts we need to look at for a couple of reasons. One, the time is only 2 years, and generally as long as you don't go over a couple of years, that's probably going to be enforceable as long as it was agreed to. As long as the person it was something they actually agreed to at the time of starting their employment. And then the scope, as long as it's limited to simply fashion design and not working anywhere in the fashion world, that's probably reasonable because it is targeted towards what that person is actually competitive with. But you don't want to make it the scope so broad that the person simply can't get a job because that's unfair to them, but it's also unfair to the rest of the industry who now can't hire for a couple of years a person who would fill a lot of possible needs
in their industry. And in the geographic location, if this whatever the company is, if they prevent you, if it's limited to just that state, if that company truly is competitive throughout the state, then that's probably pretty reasonable. But it would be unreasonable to say that you can't work anywhere in the United States, because again, that would severely limit competition for your skills, and also be an unreasonable restriction on your ability to offer what you have to the marketplace. There's a case in the book that talks about a situation where the company was based in Louisiana, and I think they had covered the whole state and with their covenant not to compete, and the court actually rewrote the clause to limit it just to a few of the parishes where they were truly competitive, and said you can't do it in the whole state because your business isn't competitive throughout the state. Different jurisdictions might handle those different ways. Some courts might just say that they're unenforceable and throw it out. They could throw out the entire agreement potentially, or in some jurisdictions they will rewrite it for you, although I think that practice is probably more on the side of either saying that the clause is acceptable or not, because a lot of judges probably don't want to be in the business of rewriting your agreement. I don't go into some of these other concepts too much, just for the sake of time and the amount of material that we have to cover. I will just say, with fraud and misrepresentation, obviously you don't have a contract if you were defrauded because you didn't actually consent. There was no real meeting of the minds because you were under a false understanding. So you didn't truly know what you were consenting to. With mistakes, if both parties are mistaken about some crucial facts that pertain to the contract, then that may nullify the contract. But if it's just a unilateral mistake where maybe you just thought that you could sell something once you bought it for more than it turns out you actually can, that's just generally going to be the risk of doing business. So you have to be careful about that. And then with duress and undue influence, duress and undue influence are both something more than a little bit more than high pressure situations like a pushy salesman or something like that. Duress is where you really we wouldn't expect a reasonable person to not go through with the deal. So an extreme example of that might be somebody puts a gun to your head, or somebody says, I suggest you sign this contract. It would be good. It would probably be the best thing for your daughter. And, with a tone that conveyed there might be some risk to you or your family. We wouldn't expect a person to not agree to it, but we also understand that they didn't truly agree to it. But we would expect them to go ahead and sign it anyways. And I recognize the slide says undue influence, so that should be influence. Okay, I'm going to take a break there, and then we'll come back with a statute of frauds.